friends, welcome back to Pen and Paper YouTube channel. Here we explain complex legal topics in the simplest way as possible using just pen and paper. So today's topic is an very important and often it is very confusing one, and the topic is nominee versus legal heir. Who actually gets the property or bank money, whether it is a nominee or it's a legal heir. So let's understand this concept step by step. So, friends, a nominee is the person whom you are going to appoint in bank accounts, insurance policies, or investments. So, we need to remember that a nominee is not the owner of the money or the property, and he is just the trustee or custodian, and he is going to hold the money temporarily on behalf of the legal heirs. So, friends, now we will see an example, and then we may be able to understand the nominee concept very well. So A is going to nominate B, who is his friend, for his bank account. So after A's death, the bank will release the money to B, for which he is not becoming the owner. He must hand it over to the A's legal heirs, such as wife, children, mother. So likewise, they will be the absolute owner here, and he is going to hold the money or the property for a temporary period, and then he is going to hand it over to the legal heirs. So friends, now we will understand who is a legal heir. So legal heirs are the family members entitled to inherit property after a person's death. So as per the succession laws we have, so under Hindu law, the Hindu Succession Act 1956, which is going to apply here, and according to that, the legal heirs under Hindu law are the spouse, children, and mother of the deceased person. And under the Muslim law, there is a Sharia inheritance rules. So accordingly, it is going to be governed under Sharia law. And for the others, apart from the Hindu and Muslim personal law, so as per their personal succession act, it is going to be determined, or the will what they are going to write. So that is going to be valid after the deceased, the property or the money. So friends, now we will look into an example where A dies leaving behind his wife and children. So they are the legal heirs here and will inherit his assets. Maybe it is money, property, such like that. So B, after A's death, so he is going to get those things for the temporary time period, and then he is going to hand it over to the legal heirs, that is wife and children. Very simple. So friends, the key point here is the nominee is never the ultimate owner of the money or the property. The nominee's role is only to collect the money or the property after the person who has handed over to him, and then later he is going to hand it over to the legal heirs such as wife, children, and mother of the deceased person. So the legal heirs are the actual owners under the law. Suppose A nominates his brother B for his bank account, but when A is going to die, his wife, children are alive, and then they are the actual owners of the money. So friends, there are some exceptions. For example, in case of company shares, the law may allow the nominee to become the owner. In some cases under the Insurance Act, special rules are going to apply. And most importantly, if a person has left a will, then the will is going to override both nomination and the legal succession. So friends, now we came to the end of the video. So a nominee is just a custodian while the legal heirs are the absolute and true owners of the money or the property. And to avoid dispute, the best practice is to always make a valid will. In case if you are going to appoint a nominee, definitely there are chances to have some disputes over there. And the person, when he is alive, it is always best to make a will, a valid will, so that the property and the money is going to be inherited after he's going to die. So this is Pen and Paper channel. Don't forget to like, share and subscribe. And for more simple explanations, please keep watching this channel. Thank you.